Two channels coming together. Oh yeah. True crime team, you better know. After the facts and defense rest, let's go. Bringing justice, doing their best. Woo! Facts are flying, truths unfolding. Criminals shaking, their stories holding. Defense rest, got the legal mind. Together they solve, justice they find. All rise, the truth's in the house. Y'all bring it up, breaking it down. Hear that call? Facts and defense, a mighty blend. Oh yeah, justice ain't gonna bend. Gavel hits, the facts commence. Defensive moves, we've got the sense. Teamwork strong, no crime secret. Yeah, they're bringing justice. Best believe it. Ooh yeah.
Keep them, but other than the objections that they've stated, are you satisfied with these instructions?
Yes, sir.
And are you also satisfied with the verdict form, with the same understanding that any objections they've already made are still standing of record?
Yes, sir.
Anything else before we bring the jury in?
No, sir.
All right, let's go ahead and do that.
Don't want to go past past 45, just for attention reasons. So, I'll ask.
And I understand I'm not limiting you, but there is supposed to be some parity between the two
Right.
arguments. So if you're both in that range, it'll be fine. If you get to 45 minutes, I'll just give you a caution on your time. I'll tell you you're at 45. That's all I'll do. With anybody about this case, not read any news reports about this case, or seen any TV articles, or not done any outside research about this case. Responsible. All the jurors are again present. On your seats is a copy of these instructions that I'm about to give you. You may follow along with me either by reading or by just by listening. Understand that I can't concur in the instructions. I'll correct it verbally. So what I say is what counts, and the final version will be provided to you in writing back. Jury instructions for the penalty proceeding. Members of the jury, you've heard all the evidence, and in a few minutes you'll hear argument of counsel. It's now your duty to make a decision as to the appropriate sentence that should be imposed on the defendant for the crime of first-degree murder. There are two possible punishments. One, life imprisonment without the possibility of parole, or two, death. In making your decision, you must first unanimously determine whether the aggravating factors alleged by the state have been proven beyond a reasonable doubt. An aggravating factor is a circumstance that increases the gravity of a crime or the harm to a victim. No facts other than proven aggravating factors may be considered in support of a death sentence. The findings on each verdict form are independent for each count, so you must independently consider the sentence to be imposed for Robert Baker and TAITON Baker. Count one, Robert Baker, decedent. The aggravating factors alleged by the state in count one are: one, Mark Howard Wilson Jr. was previously or contemporaneously convicted of another capital felony. Two, the first-degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of or an attempt to commit a burglary. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. A, that Mark Howard Wilson Jr. had permission or consent to enter a structure owned by or in the possession of Chad and Sarah Baker. And B, that Mark Howard Wilson Jr., after entering the structure, remained therein with the intent to commit or attempt to commit an aggravated assault or aggravated battery or manslaughter or second degree or first degree murder inside the structure. 3, the first degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. Killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before killing. However, in order for this aggravating factor to apply, a heightened level of premeditation, demonstrated by a substantial period of reflection, is required. A pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of a murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. Count 2, TAITON Baker, decedent. The aggravating factors alleged by the state in count 2 are: 1, Mark Howard Wilson Jr. was previously or contemporaneously convicted of another capital felony. 2, the first degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of or an attempt to commit a burglary. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. A, Mark Howard Wilson Jr. had permission or consent to enter a structure owned by or in possession of Chad and Sarah Baker, and B, Mark Howard Wilson Jr., after entering that structure, remained therein with the intent to commit or attempt to commit an aggravated assault or aggravated battery or manslaughter or second degree or first degree murder inside the structure. 3, the first degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Cold means the murder was the product of calm and cool reflection. Calculated means having a careful plan or prearranged design to commit murder. The killing is premeditated if it occurs after the defendant consciously decides to kill. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. However, in order for this aggravating factor to apply, a heightened level of premeditation demonstrated by a substantial period of reflection is required. The pretense of moral or legal justification is any claim of justification or excuse that, though insufficient to reduce the degree of murder, nevertheless rebuts the otherwise cold, calculated, or premeditated nature of the murder. 4, the first degree murder was especially heinous, atrocious, or cruel. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to TAITON Baker. Victim impact evidence. We have heard evidence about the impact of this murder on the family, friends, and community of Robert and TAITON Baker. This evidence was presented to show the victim's uniqueness as an individual and the resultant loss by Robert and TAITON Baker's deaths. However, you may not consider this evidence as an aggravating factor. Burden of proof. As explained before the presentation of evidence, the state has the burden to prove an aggravating factor beyond a reasonable doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to disregard an aggravating factor if you have an abiding conviction that it exists. On the other hand, if after carefully considering, comparing, and weighing all the evidence, you do not have an abiding conviction that the aggravating factor exists, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the aggravating factor has not been proven beyond a reasonable doubt, and you must not consider it when providing a verdict. A reasonable doubt as to the existence of an aggravating factor may arise from the evidence, a conflict in the evidence, or the lack of evidence. If you have a reasonable doubt as to the existence of an aggravating factor, you must find that it does not exist. However, if you have no reasonable doubt, then you should find the aggravating factor does exist. Finding aggravating factors. A finding that an aggravating factor exists must be unanimous. That is, all of you must agree that each presented aggravating factor exists. You should consider such aggravating factors separately, and a separate verdict must be returned as to each. I'll show you that on the verdict form in just a moment. You'll be provided a form to make this finding as to each alleged aggravating factor, and you should indicate whether or not you find each aggravating factor has been proven beyond a reasonable doubt. If you do not unanimously find that at least one aggravating factor was proven by the state beyond a reasonable doubt, then the defendant is not eligible for the death penalty, and your verdict must be for a sentence of life imprisonment without the possibility of parole. At such point, your deliberations are complete. If, however, you unanimously find that one or more aggravating factors has been proven beyond a reasonable doubt, then the defendant is eligible for the death penalty, and you must make additional findings to determine whether the appropriate sentence to be imposed is life imprisonment without the possibility of parole or death. Sufficiency of the aggravating factors. If you unanimously find the existence of at least one aggravating factor, you must then determine if the aggravating factors are sufficient to impose a sentence of death. If you unanimously find that the aggravating factors are sufficient to impose a sentence of death, the next step in your process is for you to determine whether any mitigating circumstances exist. Mitigating circumstances. A mitigating circumstance is anything that supports a sentence of life imprisonment without the possibility of parole, and can be anything which might indicate that the death penalty is not appropriate. It is not limited to the facts surrounding the crime. A mitigating circumstance may include any aspect of the defendant's character, background, or life, or any circumstance of the offense that may reasonably indicate that the death penalty is not an appropriate sentence in this case. It is the defendant's burden to prove that one or more mitigating circumstances exist. Mitigating circumstances do not need to be proven beyond a reasonable doubt. Instead, the defendant need only establish a mitigating circumstance by the greater weight of the evidence, which means evidence that more likely than not tends to establish the existence of a mitigating circumstance. If you determine by the greater weight of the evidence that a mitigating circumstance exists, you must consider it established and give that evidence such weight as you determine it should receive in reaching your verdict about the appropriate sentence to be imposed. Any juror persuaded as to the existence of a mitigating circumstance must consider it in this case. In other words, the jury is entitled to consider any mitigating circumstance. The consideration of a mitigating circumstance does not require unanimity by the jury. A juror may find a mitigating factor or circumstance in the evidence, even if it has not been specifically called to her attention by the parties. The list of mitigating factors included in these instructions that follow, therefore, cannot and does not limit your determination of what mitigation is present. Among the mitigating circumstances you may consider are: 1, the capital felony was committed while Mark Howard Wilson Jr. was under the influence of extreme mental or emotional disturbance. 2, the capacity of Mark Howard Wilson Jr. to appreciate the criminality of his conduct or to conform his conduct to the requirements of the law was substantially impaired. 3, Mark Howard Wilson Jr. has intelligence deficits. 4, Mark Howard Wilson Jr. was neglected by his adult caretakers as a child. 5, Mark Howard Wilson Jr. has a mental health diagnosis of attention deficit disorder. 6, Mark Howard Wilson Jr. was abused by his adult caretakers as a child. 7, Mark Howard Wilson Jr. lacked parental guidance as a child. 8, Mark Howard Wilson Jr.'s stepmother, Kim McMahon, suffered from untreated mental illness during his childhood. 9, Mark Howard Wilson Jr.'s mother was the victim of domestic violence when she was pregnant with him. 10, Mark Howard Wilson Jr. witnessed multiple episodes of domestic violence throughout his childhood. 11, Mark Howard Wilson Jr.'s parents abused illegal substances during his youth. 12, Mark Howard Wilson Jr.'s step-parents introduced him to illegal substances during his youth. 13, Mark Howard Wilson Jr.'s maternal family has a history of mental illness. 14, Mark Howard Wilson Jr.'s paternal family has a history of mental illness. 15, Mark Howard Wilson Jr. abused inhalants as a child. 16, Mark Howard Wilson Jr. abused cocaine as a child, teenager, and as a young adult. 17, Mark Howard Wilson Jr. abused methamphetamine as an adult. 18, Mark Howard Wilson Jr. abused drugs and inhalants as a child, impacting his brain development. 19, Mark Howard Wilson Jr. suffered from depression in childhood. 20, Mark Howard Wilson Jr. was sleep deprived at the time of the offense. 21, Mark Howard Wilson Jr. suffered from depression as an adult. 22, Mark Howard Wilson Jr. suffers from post-traumatic stress disorder 23. Mark Howard Wilson Jr. suffered from at least one traumatic brain injury. 24. Mark Howard Wilson Jr. can be redeemed. 25. Mark Howard Wilson Jr. can serve as an inmate worker if sentenced to life in prison without parole. 26. Mark Howard Wilson Jr. took responsibility for the deaths of TAITON and Robert Baker within 1 day of the crime. 27. Mark Howard Wilson Jr. was raised in severe poverty. 28. Mark Howard Wilson Jr. suffered complex trauma during his childhood. 29. Mark Howard Wilson Jr. was repeatedly abandoned by his primary caretakers for days at a time. 30. Mark Howard Wilson Jr. suffers from generational family psychological dysfunction. 31. Mark Howard Wilson Jr. suffers from mental illness. 32. Mark Howard Wilson Jr. had abnormal brain imaging. 33. Mark Howard Wilson Jr. has brain damage. 34. Mark Howard Wilson Jr. suffers from deficits in executive function. 35. Mark Howard Wilson Jr. has neurological deficits. 36. Mark Howard Wilson Jr. experienced recurrent residential relocations and school changes as a child. 37. Mark Howard Wilson Jr. experienced chronic exposure to trauma during his childhood. 38. Mark Howard Wilson Jr. had an immediate family member who was incarcerated during his childhood. 39. Mark Howard Wilson Jr. had limited protective factors as a child. 40. Mark Howard Wilson Jr. lives his life in flight or fight mode. 41. Mark Howard Wilson Jr. was unlawfully removed from his mother by his father at a very young age. 42. Mark Howard Wilson Jr. was deprived of contact with his mother for 5 years at a critical time in his childhood development. 43. Mark Howard Wilson Jr. maintains a relationship with his mother, sister, and aunt. 44. Mark Howard Wilson Jr.'s psychological and emotional development was critically impacted because he was introduced to maladaptive behaviors at an early age by the adult caretakers in his life. 45. Existence of any other factors in the defendant's character, background, or life, or the circumstances of the offense would mitigate against imposition of the death penalty. Your decision regarding the appropriate sentence should be based upon proven aggravating factors and established mitigating circumstances that have been presented to you during these proceedings. The next step in the process is for each of you to determine whether the aggravating factor or factors that you have unanimously found to exist outweigh the mitigating circumstances that you have individually found to exist. The process of weighing aggravating factors and mitigating circumstances is not a mathematical or mechanical process. In other words, you should not merely total the number of aggravating factors and compare that number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular factor or circumstance. Regardless of the results of each juror's individual weighing process, even if you find that sufficient aggravator or aggravators outweigh the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. Once each juror has weighed the proven factors, he or she must determine the appropriate punishment for the defendant. The jury's decision regarding the appropriate sentence must be unanimous if death is to be imposed. To repeat what I have said, if your verdict is that the defendant should be sentenced to death, your finding that each aggravating factor exists must be unanimous. Your finding that the aggravating factor or factors are sufficient to impose death must be unanimous. Your finding that the aggravating factor or factors found to exist outweigh the established mitigating circumstances must be unanimous. And your verdict to impose a sentence of death must be unanimous. Verdict form will be provided 2 forms. I'll show them here to you in a moment. To reflect your findings and decision regarding the appropriate sentence, There is one form for each count. If your vote on the appropriate sentence is less than unanimous, the defendant will be sentenced to life in prison without the possibility of parole. The fact that the jury can make its decision on a single ballot should not influence you to act hastily or without due regard to the gravity of these proceedings. Before you vote, you should carefully consider and weigh the evidence, realizing that a human life is at stake, and bring your best judgment to bear in reaching your verdict. The verdict forms are up here, and they will be given to you. The first one is the verdict as to the sentence on count 1 with regard to Robert Baker, decedent. We, the jury, find as follows as to the defendant, Mark Howard Wilson Jr., in this case. Just to orient you to the formatting, there are A, B, C, D, and E. There's 5 major decisions that you have to make. Those are bolded, and they begin each section. So A, aggravating factors as to count 1. We, the jury, unanimously find the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Mark Howard Wilson Jr. in this case. 1, Mark Howard Wilson Jr. was previously or contemporaneously convicted of another capital felony. Yes or no? 2, the first-degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of a burglary. Yes or no? The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes or no? If you answered yes to at least one of these 3 aggravating factors, then you will proceed to section B. If you answered no to every aggravating factor listed above, do not proceed to section B. Mark Howard Wilson Jr. is not eligible for the death sentence as to this decedent and will be sentenced to life in prison without the possibility of parole for the murder of Robert Baker. Please sign and date the verdict form and return it to the courtroom. So if you're at that circumstance, you flip to the last page, sign it, and bring it into the courtroom. Section B is on the next page. Sufficiency of the aggravating factor as to the first-degree murder of Robert Baker. Reviewing the aggravating factor or factors that we unanimously found to be proven beyond a reasonable doubt in section A, we, the jury, also unanimously find that the aggravating factor or factors are sufficient to warrant a possible sentence of death. Yes or no? If you answer yes to section B, please proceed to section C. If you answered no to section B, do not proceed to section C. The defendant, Mark Howard Wilson Jr., will be sentenced to life in prison without the possibility of parole for the murder of Robert Baker. Please sign and date the verdict form and return it to the courtroom. In that circumstance, you would turn to the last page, sign it, and you have completed. C, mitigating circumstances. One or more individual jurors finds that one or more mitigating circumstance was established by the greater weight of the evidence. Yes or no? This is not a unanimous vote here. This is just whether one or more of you finds that one or more circumstance was established. If you've reached stage C, you will always proceed to D. Please proceed to section D regardless of your findings on section C. Section D, eligibility for the death penalty for the first-degree murder of Robert Baker. We, the jury, unanimously find that the aggravating factor or factors were proven beyond a reasonable doubt in section A outweigh the mitigating circumstance or circumstances established in section C above as to the first-degree murder of Robert Baker. Yes or no? This is a unanimous vote. If it is not unanimous, you're finished. If it is unanimous, you move to section E. If you have answered no to section D, do not proceed. Mark Howard Wilson Jr. will be sentenced to life without the possibility of parole for the murder of Robert Baker. Please sign and date the verdict form. Return it to the courtroom. Section E, jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor or factors has been established beyond a reasonable doubt in section A above, that the aggravating factor or factors are sufficient to warrant a sentence of death in section B above, and that the aggravating factor or factors outweigh the mitigating circumstance or circumstances in section D above, we, the jury, unanimously find that the defendant, Mark Howard Wilson Jr., should be sentenced to death for the first-degree murder of Robert Baker. Yes or no? If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole. It will then be dated. Today is the 28th, if you complete, and signed by the foreperson. That's as to count one, Robert Baker. As to count two, we, the jury, find as follows: Mark Howard Wilson Jr. in this case. Aggravating factors as to count one. We, the jury, unanimously find the state has proven the following aggravating factors beyond a reasonable doubt as to the defendant, Mark Howard Wilson Jr. in this case. One, he was previously or contemporaneously convicted of another capital felony. Yes or no? Two, the first-degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of a burglary. Yes or no? The first-degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification. Yes or no? And for TAITON Baker, there is a fourth factor. The first-degree murder was especially heinous, atrocious, or cruel. Yes or no? As before, if you answered yes to at least one of those aggravating factors, proceed to section B. If you answered no, do not proceed to section B. He is not eligible for the death penalty, and a sentence of life in prison without parole will be entered. Section B, sufficiency. Reviewing the aggravating factor or factors that we unanimously found proven beyond a reasonable doubt in section A, we, the jury, unanimously find that the aggravating factor or factors are sufficient to warrant a possible sentence of death. Yes or no? If you answer yes, proceed to section C. If you answer no, again, he would not then be sentenced. He would be sentenced to life in prison without parole, and would be completed. Section C, mitigating circumstances. One or more individual jurors find that one or more mitigating circumstance was established by the greater weight of the evidence. Yes or no? Again, that's not a unanimous verdict. That's if one or more of you find one or more was established. Simply tell us yes or no. Please proceed to section D, regardless of your findings on section C. Section D, eligibility for the death penalty for the first-degree murder of TAITON Baker. We, the jury, unanimously find that the aggravating factor or factors that were proven beyond a reasonable doubt in section A above outweigh the mitigating circumstance or circumstances established in section D as to the first-degree murder of TAITON Baker, yes or no? If you answer yes to section D, please proceed to section E. If you answer no to section D, do not proceed. The defendant, Mark Howard Wilson Jr., will be sentenced to life without the possibility of parole for the murder of TAITON Baker. Please sign and date the verdict form and return it to the courtroom. Section E, jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor or factors has been established beyond a reasonable doubt in section A above, that the aggravating factor or factors are sufficient to warrant the sentence of death in section B above, and that the aggravating factor or factors outweigh the mitigating circumstance or circumstances in section D above, we, the jury, unanimously find the defendant, Mark Howard Wilson Jr., should be sentenced to death for the first-degree murder of TAITON Baker, yes or no. If your vote to impose death is less than unanimous, the trial court shall impose a sentence of life without the possibility of parole for the murder of TAITON Baker. Dated this blank day of October 22 in Palatka, Putnam County, and signed by the foreperson. Weighing the evidence. When considering aggravating factors and mitigating circumstances, it's up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in making your decision as to what sentence should be imposed. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: one, did the witness seem to have an opportunity to see and know the things about which the witness testified? Two, did the witness seem to have an accurate memory? Three, was the witness honest and straightforward in answering the attorney's questions? Four, the witness have some interest in how the case should be decided? 5, did the witness's testimony agree with other testimony and other evidence in the case? 6, has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? 7, did the witness at some other time make a statement that's inconsistent with the testimony he or she gave in court? The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give an opinion. However, an expert's opinion is only reliable when given on the subject about which you believe that person to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely on your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or testimony of any witness. The defendant exercised the fundamental right by choosing not to be a witness in this case. You must not be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand or give testimony in the case. Rules for deliberation. There are some general rules that apply to your discussions. You must follow these rules in order to make a lawful decision. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your decisions will be a miscarriage of justice. There's no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decisions in this matter. 2, your decisions must be based only on the evidence that you have heard in the testimony of witnesses, as seen in the form of exhibits in evidence and these instructions. 3, your decisions must not be based on the fact that you feel sorry for anyone or are angry at anyone. 4, remember the lawyers are not on trial. Your feelings about them should not influence your decision. 5, your decisions should not be influenced by feelings of prejudice or racial or ethnic bias. Your decisions must be based on the evidence and the law contained in these instructions. This time, the attorneys will give their closing arguments. The state will go first and the defense will conclude. Okay, are you ready?
Yes, Sean.
All right, Ms. Duffy, you may proceed. Please.
Ladies and gentlemen, this phase of the trial, the penalty phase, probably felt like it was all about the defendant, Mark Wilson. And it was in large part, and it's by design, by our rules and our procedure. But now that you have this decision to make and the things you're going to weigh, I want to remind you that this trial is still, in this phase, very much about the murder of these 2 boys, Robert and Tate. Brilliant Robert and smiling and full of life Tate. This phase is also still very much about how they were murdered, and not only why the death penalty legally applies in this case, but why it is the appropriate punishment for the aggravation of the murder of these 2 boys, and why their murder and how it is done and the aggravation justifies the imposition of the death penalty. It is still very much about that. And so we're going to talk about that as well as what we heard about Mark Wilson this morning. The judge just read some of the law to you, and I'm going to talk to you about that again. And your role, as you know, it is now your duty to make a decision as to the appropriate. You're going to be reminded, and the instructions remind you. Nothing's going to compel you. Nothing's going to require you to impose a death penalty. But the question is it appropriate? And that's your role. You know that there's the two punishments. And I just want to remind you that if each individual decision as a juror is to impose death, that decision has to be unanimous, ultimately, in this case. And the instructions just kind of outlined it, but I kind of want to boil it down. This process you're going to go through and the steps on the verdict form. Your decision is essentially based on 4 questions. Has the state proven at least one aggravating factor beyond a reasonable doubt? That's still our burden. Are the aggravating factors or factor proven to exist sufficient? Are they sufficient in order to impose the death penalty? I expect that one or more of you will find that some mitigation has been proven, and we're going to go through that, and it's a lower burden. So I expect that one or more of you will say there's mitigation exists. Okay. So the third question is, do those aggravating factors that were proven outweigh what's been proven to exist? And then finally, and ultimately, that question, the question we all talked to you about in jury selection, and we explained the process. Should the death penalty be imposed? When you get all the way to the bottom, should. As you heard, the aggravating factors are things that are statutory. They're set out in statute. They're limited, and the state's bound by those. And they're things that the legislature has decided increase the gravity of the crime or the harm to a victim. We still have to prove those beyond a reasonable doubt, like I said. And again, if you are to consider any of those aggravators, you're finding as to whether that's been proven, just like an element of the crime, it still has to be unanimous. Okay. Now, when you move on in the process to mitigating circumstances, that can be anything. Anything that supports a sentence of life, anything that might indicate death's not appropriate. It's not limited. I think you heard a list of 45. And the judge just read that out. That wasn't the judge telling you that those things exist. That's what the defense is putting before you and asking you to consider, and you will decide whether they exist. That's still a decision by you. But again, it can be anything, but I want to remind you that the end of that instruction tells you that it should be something that may reasonably indicate the death penalty is not appropriate in order to be mitigated. We're going to go into those, but you may find that he had a bad childhood overall, right? So I'm not going to stand up here and tell you that that's not the case. You may find that his mother was a domestic violence victim, right? But then you weigh that against the aggravation. And does that mitigating factor, which exists, does it reasonably indicate that the death penalty is not an appropriate sentence in your overall decision? The defense only has to prove that one of those mitigating circumstances exists by a greater weight of the evidence, okay? So a lower burden, but they do have a burden to prove it. Just because they say it or a doctor says it, and we're going to go into that, you don't have to accept that, just like any other piece of evidence throughout this trial. By a greater weight of the evidence, was it proven, or was it actually not even proven? And then again, I just want to remind you about this weighing process. The law contemplates that different factors or circumstances may be given different weight or values, and that's your own individual decision, okay? And it's not a numbers game, as the court has read to you, and you'll have those instructions. There's clearly infinite amount of mitigating factors that any one defendant could propose. So it's not 1 against 20, 4 against 45, they win. That's a very trivial and simplified way to get to the answer, and that's not what this process is about. It's about weighing them, and any one aggravating factor can outweigh any. You could find that 10, 20, 30 mitigating factors existed in this defendant's life, or these little things happened to him or exist about him. But what does that mean in relation to this crime and weighing it against what the defendant did, how he killed the boys, the circumstances of the killing, and those aggravating factors that are going to be proven to you? That's the analogy or the analysis, that you should go through. And so I want to start, I'm going to talk about each boy, and there's going to be some similarities. And I just, again, photos are shocking, and we had to admit them in the guilt phase for proof of a lot of things. But as you'll hear now, especially with TAITON, it's not done just to shock you. When we get to TAITON especially, heinous, atrocious, and cruel, it's the type of murder. Is it shocking? Is it vile? Things like that. But I'm going to start with Robert. Aggravating factors. The judge read these 3 to you. So there's 3 with Robert and 4 with TAITON. And I want to start by talking about the first 2. And I put check marks by these because you guys already found, or the jury already found through their guilt phase verdict, that these 2 exist beyond a reasonable doubt. Okay. Convicted of another capital felony. It can be a previous one or contemporaneous. Contemporaneous means at the same time. In this case, that is what we are seeking. Okay. At the same time, he killed Robert Baker. He killed TAITON Baker. Okay. Why? Why does that aggravate a murder? Think about it. The legislature wanted to punish more, or at least make someone eligible for harsher punishment who killed more than one person at a time in our situation. So that makes common sense, that could potentially legally qualify somebody for the death penalty. And so in the case of Robert, TAITON's contemporaneous death aggravates Robert's and vice versa. Right? And the other one that's already been proven by this jury beyond a reasonable doubt is that the murder of these boys, and here we're talking about Robert, occurred during the commission of a burglary. You already found that on the verdict form. He was found guilty of the burglaries. Okay, why is that important? Because again, not all murders, maybe as weird as that sounds, not all murders are created equal, but you guys know that. We talked in jury selection because a lot of the conversations about the death penalty was around, well, not every murder. There's differences in murders, right? Think about why that aggravates a murder. This defendant, he didn't kill them in a public place. He didn't kill someone at their workplace. In this case, the aggravator is the fact that he broke into or remained in a home he had permission to be in, their safe place, Robert's safe place. He broke into someone's house, remained in someone's house in order to commit these murders. That's not a normal murder. If you were recalling jury selection, depending on which panel you were on, if Mr. Lewis or I did the selection, we kind of gave a silly and trivial example of when we talked about premeditation. We talked about how we would go kill each other, we got mad at each other, and a quick decision to to get a weapon and kill each other in public in the parking lot. That's a murder. And that can be premeditated, and that's first-degree murder. But breaking and killing someone in their home aggravates murder. And you guys understand why that is. That makes a lot of common sense. And so now I want to talk about the third aggravator as to Robert Baker. Cold, calculated, and premeditated. You may hear us say CCP. Cold means the murder was a product of a calm and cool reflection. Calculated means having a careful plan or a prearranged design to commit murder. Now, those are new definitions for you. Premeditated is still the same with one exception, but I want to point out the similarity. This is the same premeditation definition you have. The law still doesn't affix the time. Now that we're here in CCP, I'm going to explain to you it does have to be heightened, but there's still not that requirement of, oh, well, now it has had to have been a week, 3 hours, a month, a plan, okay? There's still not that fixed time. However, in order for this aggravating factor to apply, a heightened level of premeditation does have to exist, demonstrated by a substantial period of reflection. So that's for you guys to talk about and discuss. In this case, did the defendant have a heightened level of premeditation, not the premeditation that the example that Mr. Lewis and I gave, where an individual gets upset about something in a situation, has enough time to retrieve a weapon and just kills somebody quickly. That's not what we have in this case. We have a heightened level of premeditation and a longer period of reflection, and we're going to talk about that. And first, I want to talk about it in the context of the plan. Remember? We're going back to the trial. The plan. What did he tell his mom? There was a plan to kill these boys. It wasn't a split-second decision. It was a plan.
Not like I said. I thought she was supposed to do the first half, which meant her sister and the little boy, and he was supposed to do the other two boys. What the fuck?
Remember Ms. Atkins' testimony in conjunction with that recording. What did she tell you? She told you that at her house, she confronted him. When she saw and was made aware that he wasn't cooperating, she confronted him. Did you do something? Go clear your name. Did you hurt those babies? And he told her, I did, and there was a plan. Cindy was supposed to do Sarah and the 4-year-old. I was supposed to kill the boys. Why? Because he felt threatened. The family that had taken him in, who didn't necessarily approve of how he was behaving, was still willing to take them in, drug addicts with a child, who said, if you keep doing this stuff and you don't get your life together, I'm going to call DCF. That threatened him. That upset him. And for whatever reason, this was his answer. But it was a plan. It wasn't a split-second decision. He sat with it. He sat with it. And it was cold. And it was calculated. And it was premeditated. We went through some of this at trial, but there's some other things I want to point out to you now, what I just said. The threat, those thoughts, that's longer premeditation. That's feelings of being threatened, anger, whatever it is that got him to that point. That's not a split second. We don't have a split second decision type of murder in this case. We also know he wrote that letter. I call it when I'm gone letter. That shows more forethought than the other type of basic would meet the legal requirements of premeditation. What did he do in this case? He selected his victims, the most vulnerable in the home who were not protected by the parent. He didn't go, for whatever reason, kill Sarah, and he didn't try to kill her youngest child because that youngest child was with Sarah. He went to the most vulnerable people in the home. That's a calculated decision. That was his decision. That's what you're here for, his decision. He chose to kill them on a weekday when their father wasn't home and in the early morning hours when their mother was sleeping. Again, most vulnerable, not protected. He obtained 2 weapons. Why do you obtain 2 weapons? Unless you need a backup plan, unless you need something else because one may not work. There was a gun. He didn't choose the gun. 2 weapons, just in case, because your plan is to make sure they die in this cold manner. A knife, and a hammer. He could have gone in and shot them, and there would have been no suffering at all. That's not what he did. Again, he entered someone else's domain that he was a guest in, that he entered that. That's a decision. As to cold, calculated, he approached Robert in his sleep. We know that based on the evidence. We know that based on what he said in the interview. There's no confrontation or provocation. This isn't heat of the moment. He approached these kids in their sleep. And despite that he told law enforcement that he killed TAITON first, the evidence suggests that he killed Robert, the smaller and the younger child. And we went through that in the guilt phase about why the physical evidence of the DNA suggests that. This was the only blood and DNA left on that knife that got transferred to the paper towels when it was cleaned off. It was TAITON's. It was TAITON's. And I think the scene suggests that. We'll talk about it when we get to TAITON. He took Robert's phone. I don't know if that was to prevent someone from getting help quicker or he wanted to take it to pawn it. We don't know why he took the phone, but that was a decision he made. Sarah testified and that they went to sleep right there with their phones. That's what they did. We know he approached him in his sleep. We know there was a phone cord right there without a phone attached. And then they found the phone in his hoodie with the kid's blood on it. That's a decision. It takes time. He covered him with a blanket. And again, there's no evidence of impairment, and certainly not the level of impairment that would take away the fact that all of this was cold, calculated, and premeditated. What do we know that he told his expert? And I think it was Dr. Scully, because she would have gotten most into the substance abuse. He said he had his last beer the night before. He said he smoked marijuana the last time the night before. Now, he told her he did meth in the morning. She didn't bother to ask him what time, but he was clearly willing to tell her about these things. But we know the boys were killed between approximately 7 and 9 a.m. when they get back from the convenience store and before they leave for the doctor's appointment. So if his last beer and his last smoking of marijuana was then, midnight, 11 o'clock the night before, what did he also tell Dr. Scully? I can do okay on meth. I go to work, I can function unless I mix it with alcohol. So we don't know how much. He's not mixing it with alcohol at that time. Sarah sees him the night before, and at that point, he's smoking marijuana, but he's fine. Nobody at the doctor's appointment notices anything weird or odd about the defendant.
Objection, that's not meant.
So talked about several times. And then somewhere between, law enforcement called it 10:30. I think Deputy Higginbottom testified it was shortly thereafter when he arrived on scene, when he interviewed the defendant, those 3 short audios. Is there any signs of impairment? And no, and not, certainly not any sort of level of impairment that would mitigate or remove his cold, calculated, and premeditated design that he carried out that morning. There is just no sign of any level of impairment that would erase any of this or mitigate any of this. It was calm. He had a prearranged design and a substantial period of time to reflect on this. From the time he made the decision to when he wrote the letter, to when he obtained weapons, to when he went in the house, to when he killed Robert, and he did all of the things, and then he went and moved on. That didn't stop him. He moved on to TAITON, and we're going to talk about that when we get to TAITON. All of that, ladies, proves that this murder was cold, calculated, and premeditated, even to the heightened level of premeditation required for this aggravator. And the defendant, it's interesting, he actually says that it was done in a cold manner.
You hit each one of them multiple times and then cut her through. What kind of anger were you feeling? Much. Just cold to her. Yeah, it's cold.
The detectives are asking him, assuming that possibly one of his feelings would have been anger, rage, things like that in the middle of a homicide like that. So they're like, what kind of anger were you feeling? They're trying to get him to talk about anger. I wasn't feeling angry. I was just cold.
The one thing I was pissed off after the fact because she was acting like I had done something that she wouldn't do.
So that was in response to, again, that same line of questioning. You weren't angry? No, I wasn't even pissed off until after when Cindy was acting like I did something that she hadn't told me to do. That's when you got angry. Take count 2. Tayton Baker has the same 3 aggravating factors, and then a 4th, heinous, atrocious, and cruel. Okay. We've already talked about the first 2. Okay. These were proven and found by the jury beyond a reasonable doubt. Those have been established. CCP as to Tayton, obviously similar facts. Similar facts apply. And then again with Tayton, after killing Robert, he continued on. That didn't deter him. Seeing Robert, seeing what he did. And then the evidence, as we talked about in the guilt phase, suggests that Tayton, who was likely sleeping on that floor where he always slept, clearly heard something, got up, because where do we know he was first attacked? And we'll go through those photos on the other side of the pool table. So now Mark Wilson knows I've killed him. He's up. I'm still doing this. He's up. He's awake, Tayton, and there's probably going to be a fight, but I'm doing it. I'm doing it. And he moved forward. The fighting back and the crawling away and everything we're going to talk about under heinous, atrocious, and cruel, that didn't deter him. Nothing stopped him from the plan that he set out to do from the very beginning. And the same thing, he made sure Tayton was dead. He made sure the slitting of his throat would have killed him, but he made sure with all of the hammer strikes and all the blows that he was dead. He switched weapons, ladies. He switched weapons. That's cold, calculated, and all of those things take time to do. And again, the same thing, no evidence of impairment at the time of the homicide. So as to TAITON, you have this fourth aggravating factor. Heinous, atrocious, and cruel. And just like it sounds, these are the definitions. It means that if a murder, if the circumstances of the killing are especially wicked, vile, shockingly evil, if the way the murder is done is designed to inflict a high degree of pain, that is what qualifies someone for the consideration of the death penalty with HAC, okay? And this is one of the times where you can actually consider, and that's why Dr. Fulcher, even though some of it from the scene, some of it seems very obvious, right, ladies? It's obvious that he was conscious. It was obvious that, you know, there's movement in that room and he's alive as he's being attacked, but we don't just rely on that. We brought in Dr. Fulcher, and you can, and you should, in considering how heinous, atrocious, and cruel the murder of TAITON Baker is, consider what he went through. High degree of pain. He was conscious and he was awake. The kind of crime intended to be included as especially heinous, atrocious, or cruel is one accompanied by additional acts that show the crime was conscienceless, pitiless, or unnecessarily torturous, okay? So that's why all of these things with TAITON are so important. And like I said, the circumstances of the killing and that medical testimony provided by Dr. Fulcher. So what do we know? We know it appears that he was first attacked here. We know that there was a 13-foot blood trail. You see the blood under the pool table. You'll see it closer to the wall when we move around. There is movement. He is conscious. He is awake. That is wicked. Wicked. This is shockingly evil. That's why I said earlier, it wasn't done just to shock you for emotional purposes. It's legally what you can consider. It's shockingly evil. This murder is shockingly evil and torturous to TAITON Baker. Look at the blood. Look at all the movement in that room. Look at the large blood off to the left of his body, and we know, what did he leave right there? We know he left a handprint going for his phone. He was awake. This was painful. He was cut in his neck, and it transected one of the sides, but not both sides, which is how he was able to keep moving and living just a little bit longer. Defensive wounds, we know. We know what he did. And so that's what Dr. Fulcher was there to sort of medically put in context what that scene tells you. He is a triple board certified chief medical examiner, and he explained to you why he knows that the sharp force injuries, the knife wounds, occurred first, because he told you had those extreme blunt force injuries happened first, he would have just been unconscious. He may still have been alive. His heart may have still been beating. I don't know if you remember that testimony, but he wouldn't have been able to do all that movement around the room, okay? He would not have been able to do that. He only transected the right side of his neck, so he still had blood pumping to and from the brain. And so Dr. Fulcher told you that, and obviously approximations. But he said medically, he would have been conscious for at least 30 seconds, which is clear that that happened in that room. There were 3 large neck wounds. What did he tell you? There was evidence of a sawing motion used, and then nearly 20 total knife wounds, some slices, some stabs, all of that evidence that he talked to you about. That is unnecessarily wicked, evil, painful, and torturous to Taiton Baker. We know he was fighting back, not just from the obvious scene, but Dr. Folter testified about a defensive wound. If someone is unconscious and out at the time that they're being attacked with a knife, their hands are not. That's why it's known as a defensive wound. He's still conscious. He's able to react. He knows what's happening. He's watching this man kill him. And he doesn't know where his parents are, and he doesn't know where Robert is. He might know Robert's close. He may even know what happened to Robert. We know he got up and moved around that room, but he knows who's killing him. And he's fighting back. And even the blunt force injuries, they occurred last, but what was so important about the blunt force injuries to his head? Not all of them, but many of them you saw. And again, it's why we show those awful photos. He caused skull fractures, holes in his skull that covered the brain. And now you guys have seen all about the brain through the other evidence, but he caused holes in bone, and which caused injuries in some of the hits to the underlying brain matter. And Dr. Folter testified about that. The amount of force used in the sharp knife wounds, it was unnecessarily torturous, caused a high degree of pain, shows a complete indifference for the suffering of another human being. And that is why HAC applies to Taiton Baker. These aggravating factors, ladies and gentlemen, the 3 for Robert and the 4 for Taiton, you should give them great weight. Each and every one of them that you find, great weight when you go to make your weighing decision. There's reasons why these aggravate a murder. And you should give them great weight. After you find one or more aggravating circumstances beyond a reasonable doubt, and after you find that those are sufficient to warrant the death penalty, you'll move on to considering mitigating circumstances. And again, I gave you the definition earlier. There's a list of 45 for you to look at. 45, okay? And again, I expect you guys to find that some mitigation exists in this case. I'm not going to stand up here and argue against all of it, but I'm going to put the mitigation in context and talk to you about how that weighs against this murder. This murder, okay? I've kind of lumped these in larger categories because that's, you can kind of put them all in different areas. And so I want to start about, talking about childhood trauma, and I may not have all 45 on here, but I tried to get all of them. So you'll go by the list that you have. But large in part, you heard about Mr. Wilson's childhood, that he was neglected, taken from his mom, the violence that he witnessed on his dad commit on women, not on him, but on women. And all these various things that you'll read about. And I want to ask you and remind you that a lot of this occurred before Mark Wilson was about 13 or 14 years old. Then he came back to Florida. Then he came back to where his mom could keep an eye on him. And he went to live with his mom's dad, right? She told you that this week. His maternal grandfather. And that man didn't sound like he had a great past, but he had turned himself around. That's according to Mark Wilson's mom. And he was doing right by him. And he wasn't violent anymore, and he wasn't drinking anymore. And he was able to be here, away from his father. In all of those teenage adult years, he almost graduated high school. He went through 12th grade. He dropped out at the end, and he was able to visit his mom, and he established clearly a relationship with Kayla. So he was away from that. And this murder did not occur when Mark Wilson was 18 years old, 19 years old, 20 years old. Mark Wilson was 30 years old and had lived a good 12 years removed from the violence and the neglect in his childhood. And so I just say that to remind you, yes, none of these things are good. No child should have to go through this. And they've proven that a lot of that happened. We didn't fight against it. But when you consider it as a mitigating factor for the murder of Robert and TAITON at 30, how much weight do you really give that? How much weight? I would suggest to you that back in those days, had he committed any number of crimes, it sounds like he had done some of those things. He had committed theft, he was doing some drugs, say he got in a fight, and there was a criminal case back in his early childhood. Those mitigating factors would weigh heavily on that behavior at the time, to me. That's your decision. It's more in context. It's closer in time. And I'm not saying that he moves into adulthood and he just forgets and has a wonderful life, but he's 12 years removed and he's been safe for some period of time. He's had 1, 2, 3 adult relationships, and he's been making his own choices and his own decisions. And he went through treatment, and he still chose to be around people, places, and things that made him go back to drugs. Those are his adult choices. So when you look at childhood trauma, yes, but what does it weigh in the decision you have to make in this case of the punishment he deserves for the killing of Robert and TAITON? That's the question, okay? That's the question that you have to ask yourself and each come to an individual decision on. More. There's 2 slides for it, and I probably don't have them all there. But again, I mean, if you just look at one, he had an immediate family member who was incarcerated. I think they mean his dad. Listen to whatever they say, but they might be referencing his father who went to jail. Yes, his father went to jail. How does that weigh against the heinous, atrocious, cruel, premeditated murder of TAITON and Robert? You see what I mean? That's the question. And a lot of that evidence came from a lot of the experts, right? They all tried to take a history, but the explanation of childhood trauma came from Dr. Quinones, right? And he took a history like everybody else. He explained trauma and childhood traumas and what that means for that child and ultimate adult. He never asked the defendant how those things, how is childhood trauma still affecting you now? And more importantly, as a 30-year-old man at the time of the murder. We don't know, because the very people that were his people to ask didn't bother asking. He still had, now he clearly an addict and he had substance abuse problems, but he still had 3 relationships, it sounds like, with adult women where there was no violence. There's no domestic violence from Mark Wilson on to the women in his life. So he learned that that's not what he wanted to do, right? He never asked. Dr. Quinones stopped. He took the history and just explained, this is what childhood trauma does to developing a person, right? But we're far removed from that. And what does that mean? What does that mean to help you guys make a decision? We don't know. We don't know. Other mitigating circumstances you will hear, there's a lot just surrounding, again, his family, as far as what negative things in the family impacted him. And then I suspect you'll hear some other mitigators, and I want to talk about some of those now. There's one that you heard on the list that he can serve, should consider as mitigation, that he can serve as an inmate worker if sentenced to life in prison without parole. That was from, I guess that was a point of Mr. Benasco's testimony. I asked him, you can manage him as a life inmate, can you manage him as a death row inmate? You guys heard about the different lifestyles, right? I don't see how the fact that Mark Wilson can go, not gonna live a free life, he sentenced to life. No, he'll be told 24 hours a day what to do. But he'll be able to work, apparently. He will be able to wreck with all of his new friends. He will have a lot of communication privileges with his family. How does that mitigate the fact that he can work in DFC? I don't see how that has any weight in relation to what he did to Robert and Tate Baker. Another one that you will see on there is responsibility or acceptance. And Mark Howard Wilson took responsibility for the deaths of Tate and Baker within 1 day of the crime. That's what they want you to, I'm assuming, weigh heavily. I'll let them argue it against these murders. What did he really do, though? You gotta look at that. There's different ways people take responsibility. Mark Wilson didn't take responsibility in a way that should weigh heavily on you. He knew that he killed those boys. He went and left and went to a doctor's appointment so his girlfriend could get WIC benefits. So we're already moved on to ourselves and selfish needs. Then he arrives back at a house to wherein all of the family is gathered outside. Everyone is devastated. And he knows exactly what happened. And of course, for self-interest, he's not going to say anything. He obviously wants to get away with it. That makes sense. And he lies to Deputy Higginbotham. He even tries to put Deputy Higginbotham off on another track. Hey man, I wanted to bring it to your attention, but there was a Mustang that broke down the other day in front of the house. Y'all should check that out. And then his mother had to prod and press and eventually get it from him. Thank goodness. And then she got it for law enforcement. And then what did he do? You guys had to watch that 4+ hour interview. Did he come in at that point knowing that he was caught? Yeah. He lied for almost 2 hours. They showed him, or excuse me, played for him the audio of his conversation with his mother. And you spied on me? And then still tried to deny it, still tried to act like that wasn't true. And eventually he had to admit it, right? He had to admit it. And he kind of broke down. And he admitted it. But did he give anybody any details? Did he try to help anybody understand what was going on? No. So when you look at the mitigator that said he took responsibility, ladies and gentlemen, I suggest you give that no weight in this case. You're gonna hear a number of mitigating circumstances about his intelligence, his memory, and brain damage, and I want to comment on those. What did we hear? You heard from a lot of experts. The only expert to say that this defendant has anything wrong with his intelligence or his IQ is Dr. Kropp. Dr. Kropp, who administered an intelligence test, well, his assistant did, and Dr. Meadows told you, well, I got all that data, and it didn't make sense to me, because when I met with him, he seemed pretty average. And then I read the raw data, and then it made sense why he might score 75, because there's a ton of notations by this assistant saying how distracted Mark Wilson is the whole time he's taking this test, because they're trained to look for those things to further understand how someone is during test taking. Tests aren't going to be accurate if you're not putting forth your best efforts. I'm not suggesting that was even done on purpose. The point of it is the examiner noted it, and it does explain what seems to be a deflated IQ score. But did Dr. Kropp tell you that? He just told you he's a 75 IQ, he's borderline low intelligence. And he didn't talk to him, otherwise he just administered tests via Zoom. And he didn't talk about why that IQ score didn't make any sense. Their own other expert did, Dr. Quinones, childhood trauma doctor. He found him to be of average intelligence. He's a psychologist, just like Dr. Kropp and just like Dr. Meadows. And then Dr. Werner from the state as well yesterday at the very end. He's a psychiatrist, clearly deals with all kinds of populations. Average intelligence, I wouldn't have even needed to order a test because I wasn't concerned. So again, what do you weigh? What does his intelligence really even have anything to do with the murders? But how do you weigh that? Look at Edith. Did they even prove he has an intelligent deficit? I don't believe they did, even by a great weight of the evidence. TBI, and obviously the brain damage. You heard from two radiologists. Dr. Snyder was the one from the defense, and then the state called yesterday Dr. Negan, the doctor, first thing in the morning. And essentially, they agree on what's present, right? The three little marks of scars. But what's important and why the state wanted Dr. Negan to talk to you is, what does that mean? Is that even abnormal? And he explained to you, you guys heard him talk about that that's not even that abnormal. We all get scars as we age, and then the PET especially, there's no loss of volume. It's a completely normal PET scan. And then Mr. Lewis said, well, what do these little scars mean that you agree are present? And he wouldn't expect to see necessarily any symptoms. And of course would always refer out for what? Clinical correlation, right? Okay, to see, are these things causing any problems? And so then that's why both, the defendant had Dr. Nelson, and then the state had Dr. Werner. They're both medical doctors. Nelson's a neurologist. Werner is a psychiatrist. So Werner deals more with people and people's problems than Dr. Nelson does, but he still saw him and talked to him and looked at those scans as well. And Dr. Nelson just said he has a TBI and it affects him, right? Not a lot of detail why. And also, Mr. Lewis spent a lot of time with him. He also didn't ask about anywhere near the crime. How is it affecting you in your daily life? Even a month before that, any time would have been nice. All of that information would have been good to know. But they don't ask. They certainly didn't ask about that day. Certainly didn't ask about that day. And we don't know where, as Dr. Werner pointed out yesterday, and Dr. Nelson, we don't know how those scars got there. It could have been from birth, could have been due to drug use, it could have been to a head injury. But do you really even have any evidence of a head injury? There's been some car accidents talked about. He fell off his motorcycle. He never went to the hospital. And sometimes he went to the hospital, got checked out, never had any treatment for those. And the doctor In 2010, Dr. Levin, that Dr. Warner focused on, Dr. Nelson didn't focus on that, but Dr. Warner said, well, here's another psychologist, psychiatrist, who evaluated him in 2010, back 12 years ago. How was he doing that? Because all of those issues should have been there, right? And there were no psychiatric or psychological organic brain damage issues correlated in that clinical interview, and certainly not now. So they're just merely saying those things exist, we don't know how they got there, and we certainly don't see it affecting him. Dr. Warner and Dr. Negan are saying that on the state in his daily life, and absolutely, we don't know on August 26th because nobody asked.
Not trying to cut you short, Mr. We're about 5 minutes past the time.
Okay. And then, same thing, mental health, you'll see about diagnoses that the defense put forth. ADD, okay, maybe he got diagnosed that as a child. Dr. Quinones, and I apologize if I get something wrong, but Dr. Quinones couldn't diagnose him with ADHD. Dr. Quinones says he only suffers from provisional PTSD, which Dr. Meadows disagrees with. So you may find that he suffers from ADHD and PTSD, but again, I think what's important in how you weigh it is in relation to, did it affect him here? Did it affect him for the reason we're here? If it did, if there was evidence of that, that might be more weight, right? But there's not, there's just not. And finally, some of the two, I call it psychological considerations. These are things that doctors have to speak to, psychologists and psychiatrists, okay? And if you read the first one, the capital felony was committed while the defendant was under the influence of extreme mental or emotional disturbance. Well, you might say, you might think for a minute, well, Ms. Dutton, anybody who committed this murder is like a disturbed person, like in a layman's like reading of the word. But that's not what these two aggravators go to. That aggravator and the capacity for him to appreciate the criminality of his conduct, these are all speaking to what's going on in his mind, okay? And that is why they put forth experts to testify to those two. The only expert from the defense who said that these two apply was Dr. Nelson, the neurologist. Okay. Dr. Quinones sort of said, tried to say that first one on his direct through Mrs. Peoples. And I got up and I said, Dr. Quinones, do you remember telling us just 10 days ago that you could not and you would not opine on these mitigators because you did not ask him about the crime? And he actually rolled that back on cross. He took it back. Ms. Peoples asked him questions. His body language and that's for you guys to judge how he was answering those questions. I submit to you, he didn't want to have to answer that question because he had already said no. But he tried to tell you yes. I got up and reminded him, no, you said no. And you said no because you never asked him about it. So it makes perfect common sense, ethical sense, all the other things that Dr. Meadows talks about, that you couldn't opine on this because you didn't bother to ask him about how he was emotionally or mentally functioning around the time of the crime. And then Dr. Meadows is like, no, these don't apply. He explained to you why it wouldn't have been under a general emotional disturbance or a substance abuse, meth, psychosis. He explained why all of that didn't apply. And he also explained why Mark Wilson absolutely appreciated the conduct of what he did. People that don't know what they do is criminal, they don't hide and wrap weapons. They don't clean them off and go put it in a trash can on the other side of the house. They don't lie and cover up and deceit and point cops in other directions because they actually don't know what they're doing. That's an extreme psychological, emotional state to be in. There is no evidence that those two mitigators have been proven in this case by any professional. And again, like we heard in the first phase, you don't have to believe, you don't have to agree, you don't have to buy anything that these experts told you if you don't want to. That is up for you to decide, and it's why the state tried to bring you a few to touch on the areas and to shed light on why. What did both Dr. Meadows and Dr. Werner say about what was so important? Now, Ms. Peoples tried to point out through, I think, Dr. Meadows, well, the state didn't send you school records, I think, which there's really just said he was absent some. Okay. And we didn't send them an Arizona DCF record or something. And she was pointing out they sent you only things about the crime. Well, that's not true, because he had all of the expert stuff. He had all of the history. He had all the substance abuse information. But what did they not send, make available, or even if they did, what did their experts completely ignore? Everything about the crime. And so Dr. Meadows is just trying to put it in perspective in his profession and the way he does an evaluation. Of course, all those things, you get them. The history is so important. And then does any of that history, did any of that have anything to do with why we're here now? That's the question. And so I think he was more comprehensive, and he took a more honest approach in how he wanted to look at the defendant. He didn't take at face value the denial of I don't remember. The amnesia, remember that? The selective memory that this defendant seems to have. Dr. Meadows went through all of that. And a lot of that's probably common sense. And you may be sitting there, Dutton, I didn't need an expert to tell me that, because it's sort of obvious when you look at the day, right? But just in case, we ask him, is there a psychological disorder that would have caused that type of amnesia? No. And he explained if someone actually gets a substance abuse or otherwise episodic amnesia, that looks like this. And he explained how it would be a larger block of time, and you wouldn't come in and out and only forget things negative against you. That doesn't make any sense, ladies and gentlemen. So when you look at all of the expert testimony, just remember that. You absolutely can reject anything that you heard from an expert in this case and not accept it as credible when you look at the aggravators and when you look at the mitigators in this case. Mark Wilson executed this cold, calculated, and premeditated plan on both of these boys. And then the way he attacked Peyton Baker was so heinous, so atrocious, and so cruel. That should weigh very, 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 very heavy on you in this decision. Tayton had enough thought and consciousness to crawl 13 feet. He had enough thought to know he was hurt, he needed help, he was going to die by the man that used to take him fishing and do things outdoors when his dad was gone, and he knew there was no help within reach. So he left that bloody handprint behind when he was trying to get to his phone. He knew that's torture. That's pitiless. And that's what happened with Tate. That's the type of death that is wicked, vile, torturous, and causes the suffering of another to such a level that it can't be ignored. The defense gets the last word in this phase. That's how the rules work, okay? And I expect that they are going to come up here and obviously talk about all 45 and all these mitigators with you, okay? And they will tell you that there are reasons to vote for life. Okay? I don't get to come back up, so I just want to remind you of what we also need to consider. They will remind you that it takes only one of you, and that's true. They just want one of you to spare his life. They will remind you that he is a human being and that his life has value. That's how they started their opening in this phase. And he is a human being. Mark Wilson is a human being whose life had value, but he is a human being he's an adult now, who made numerous decisions in his life, in his adult life, that got him on the property at Shiloh Road because he couldn't take care of his own child and they weren't in good situation. He made a number of choices that put him in that situation, and then he felt threatened. That's the adult Mark Wilson. And he is a human being, but there's some human beings that by their actions, they don't deserve the freedoms that you and I share. Some of them go away and are punished for a short time, others for life, but they still get to walk around the Department of Corrections and enjoy some freedom. They have a life. They can talk to their families. And then there are other human beings that deserve less than that. They deserve the worst punishment that the law allows. They deserve death. That's what we're really here to decide. And Mark Wilson Jr. is one of those people that just deserves death for what he did to those boys. Junior, the 8-year-old that got abandoned, didn't do that. Mark Wilson did that. The adult man. And in jury selection, we talked about the death penalty in different phases. And initially, we were just getting your ideas and we asked, could you? Are you one of the people that could do death and could do life? And all of you wouldn't be here if you had said that. All of you said I could, in the right circumstance, impose death, right? And then the attorneys probed a little further. We weren't allowed to talk about our facts, but we tried to give you some ideas of what you may see. Both sides did that. And what the state was trying to do is figure out, would you? Would you? There's a concept of I could impose the death penalty. And now we're asking you in jury selection to sit, pretend you're in that seat. Would you actually do it if you felt that the case warranted it and the aggravation outweighed the mitigation? Would you actually be that person? And you all said you would if it felt that that was the appropriate thing to do. And so now I know you'll go through the verdict form and I know you'll get all the way to the end on both boys. And the very last question, the E section, is asking you, should. You said he could, you could. You said you would if you felt it was the right thing. And so now we're asking you, should he? And that doesn't have to be your answer, but should he? And I'm not asking for 2 of you, 4 of you, 6 of you, 9, 10, or 11. I'm asking all 12 of you, 12 of you, to say he should, considering everything. And if you believe the aggravation outweighs the mitigation, I'm asking all 12 of you to say he should be put to death, because that's what the aggravation and mitigation support. And that's just what should be done. And I know you can all do it. Thank you.
Ms. Peters, you ready?
Just one moment. Yes. Your maybe let's have a short break.
We can, take 15 minutes. So we'll be back at 10 minutes of 11. Please do not discuss the case until you.
Rise, yours next quarter.
All right, you may be seated. We'll be in recess for 15 minutes. Is there anything you need to know?
State took an hour, so we can start. I think hour.
They took an hour and 6 minutes. What's that?
I just wanted to
You
know.
have at least that much.
Okay.
Okay, that's short. I'm just gonna, again, I'm gonna tell you at about 45, 50 minutes, just for your orientation. That's what it's like.
Okay.
I'm not cutting you short.
Sorry, I was off.
Yeah.
Are you ready? They're ready. All right. let's go ahead.
All rise, jurors enter the courtroom.
All right, please be seated.
Good morning. Again, thank you for your attention to this case. Solving decisions before you. Yes, there are 45 mitigators, and I'm not going to go through each and every one.
Thank you. So sorry. We're used to it.
It's hard to hear.
Go ahead.
So I was thanking you for your attention and letting you know that of the 45, I'm not going to go through each and every one. I've been very attentive in this case, and I'm just going to ask for attention at this final stage. Now, the state did mention that we're going to ask for one vote for life. And that's not true. I'm actually hoping that all 12 of you, for your own reasons, can give a vote for life. The law only requires one. Now, Mark Wilson Jr. has admitted to his actions on multiple occasions, to his mother, to law enforcement. And he could have exercised his right to remain silent. He could have exercised his right to counsel. He didn't do that. He confessed. He accepted responsibility. So we're in phase 2. And at this point, you're now deciding punishment. The next 12 individual verdicts. Each one of you must decide. You don't have to be unanimous. You don't have to agree. Each one of you is going to make an individual, personal, moral judgment on the mitigators, on the aggravators. Well, on the aggravators, you need to be unanimous, but as to the mitigation, it's individual. And it could be something that I don't present that won't be in the jury instructions of that group of 45. You're allowed to choose your own mitigation, okay? So let me start with what we saw in this case for the penalty phase, and that was Dr. Snyder. I think at this point everyone's near expert level in brain scans. I know more than I did before, but Snyder and that's Dr. Snyder and the state doctors needed both agree that there were spots or scarring on the brain. All right, so both of these doctors are board certified neuroradiologists, and they both saw the same spots, and they both said that you need clinical correlation for it. And they're both in agreement that it could be caused from trauma, so it could be a car accident or a head injury. And then Negan actually fleshed that out with more detail, that it could be caused from neonatal or in utero injuries, meaning while his mother was pregnant with him. That it could be substance abuse, and then he went on to say diabetes and stroke. So he gave a long list of all the different reasons that those spots could be there. But at the end of the day, the cause is unknown because you need clinical correlation. And then, again, because they're all in agreement on where these spots are, we have one in the corpus callosum. Dr. Warner, that was a state doctor, gave us an explanation about memories and how they're formed. They're formed on the brain that lays tracks, meaning those memories are formed in that manner. It's a laying of a track. And where did she say that occurs? In the corpus callosum. That's Dr. Warner explaining that to you as to where memories are formed. So now you have Negan and Snyder telling you that there's a scarring injury on the corpus callosum of the brain, and you also have been informed that that's where memory is formed. These doctors, meaning Dr. Warner, also told you that Dr. Croft in the TOM, that's the test of memory malingering. So Warner and Croft are in agreement that he's not malingering in terms of his memory. His performance is his best effort. So there's problems with the memory, and he's not faking the problems with the memory. Now, Warner didn't fully agree with Mark's performance in terms of not telling her why the homicide occurred. But the memory and the deficits and the problems that are there aren't just coming out of the sky. You can trace it back to the scarring on the corpus callosum. And how did that happen? I have no hospital records for you. I have no police reports for you. I have next to nothing but the word of Kelsey and Mark and others about the trauma that these children lived through. You have the word of his mother. Again, she didn't go to law enforcement and talk about the times that he choked her out while she was pregnant. And we'll get to the mom in a second, but understand that what we do have is agreement on where the scarring is and how his testing is performed or his results are. And then the other thing that quickly that the state had brought up was Dr. Levin. That's the doctor that saw him 12 years ago in 2010. That's a doctor who made no mention of any memory deficits. That doctor is a psychologist, not a neuropsychologist, not a neuroradiologist, and that doctor had no imaging. All right, so the doctors that are actually doing the testing are finding similarities in their results. The state doctors aren't agreeing as to his memory about the homicide, but they're all in agreement about where the spots are and some of the deficits that he has. So then we got into the PET. There's an abnormal temporal lobe. Negan doesn't agree with this one. Just to be clear, the state doctor is not agreeing about what Dr. Snyder saw here. However, Dr. Snyder, on his review, did it in color. That's his practice. He's doing thousands of these. It's not some special color for this particular case. This is how he operates. This is what he does, all right? So in a summary, he says that there's scarring on the left parietal lobe and some volume loss. There's scarring in the GU of the corpus callosum, that's for the memory. And then here we are, the abnormal PET exam with decreased metabolism in the bilateral hippocampal regions, amygdala, and temporal lobes. This is important, okay? He says we need clinical correlation for that because that is going to impact the limbic system. I just throw out a lot of that. Okay, so what happens is that the next set of doctors come in and they provide the clinical correlation to explain what Dr. Snyder has identified in this imaging. So Dr. Croft, the neuropsychologist, so he performs the test that corroborates the damage that we saw in the PET. Okay, so the radiologist, meaning Negan and Snyder, so both of the doctors that look at the imaging are both saying, we see the same spots, we need a correlation on that. Dr. Snyder, Dr. Croft does his testing, says the IQ is low in the areas that it's not across the board, right? He's able to work as a mechanic, but he is testing low in certain areas of his IQ. And that causes some difficulty in decision making. He has troubles with memories and poor memory retrieval. So brain development issues may occur in utero from child abuse, from car accidents, motorcycle accidents, where he doesn't use a helmet. Again, this isn't in an absence of testimony, all right? You can't ignore what you've heard from Kelsey, from mom, when we're talking about the brain damage. And I know I'm jumbling this all together, but back to the PET for a moment. So Dr. Snyder ran a database, a normative database, and the amygdala and the hippocampus were 2 to 3 standard deviations below the mean. That database was made up primarily of people in advanced age, 60s, 70s, 80s. And Mark was testing below that group, below that database. So then we have our Dr. Stephen Nelson. He's the neurologist. He's the one that actually had that, the brain that he was able to take out and pull apart and show you the different parts. That doctor said a developing brain needs to be nurtured to grow properly. That exposure to trauma can harm the developing brain. And when there's injury to the parietal lobe, like we have here, there can be problems with regulating emotion. Now, Mark is doing well with regulating his emotions now, like he's in custody. It's an extremely structured environment. He's got a few areas, if any, to make any choices. They're telling him when to get up, when to go to sleep, when to eat. There's no choices for him there, all right? So the other thing that we're learning from Dr. Nelson is that when you have problems with the limbic system, that you become stuck in flight or fight mode. Flight or fight mode. And he's not the only doctor to say that. We had multiple doctors walk you through that. So Mark's symptoms fit what Dr. Snyder saw in the imaging. His brain does not function normally. And at this point, let me remind you, we are not here in the penalty phase to give you excuses or defenses to what those boys went through. We're here to give you mitigation reasons to vote for life. They were crushed brutally. This is not an excuse, all right? We're here to give you mitigation reasons to vote for life and give you some explanation as to what's going on with Mark's brain. So Dr. Nelson then set those two key mitigators, and it's not just him, we've got other doctors supporting this, that the capital felony was committed while the defendant was under influence of extreme emotional, mental or emotional disturbance, and the capacity of Mark Wilson Jr. to appreciate the criminality of his conduct, or to conform his conduct to the requirements of the law, was substantially impaired by the brain damage. Not as an excuse, again, as mitigation. So in summary with the brain damage, and again, I'm running through this, I'm not going through all 45 with you. He's got abnormal brain imaging. Again, those two doctors, Negan and Snyder, disagree, but then you have the other doctors supporting that there's a problem there. You have suffers from deficits in executive functioning, neurological deficits, intelligence deficits, and he suffers from mental illness. There's been testimony about depression, and anxiety and things of that nature. And let me pause with the intelligence deficits, because I know the state talked about that a lot during the trial. It's not to say that he's so intellectually disabled that he can't tie his shoes, but the testing does show that there are deficits in his intelligence. So a family history of mental illness, and again, I'm going to go through these quickly. They're all sat through the trial, all right? So his great-grandfather has a PhD, really intelligent individual. Right, and he also had mood swings, very anxious, and then after the stroke, he mellowed out, he was a different person. His grandfather, Richard Wilson, again, another individual with a PhD, really intelligent, was very violent. And then later in life, he's then convicted of sex with a minor, okay? So he's now a registered sex offender. And this was one of the caregivers over Mark in Arizona. Then his father, and this is a picture of his father as a young man. His father, and then you heard from his sister Pam, who talked about living in the home with his father Richard, Mark's grandfather, that he was very unpredictable, really wild mood swings, and the violence. Not like Wilson Sr. was, but there was already, the violence was there. And she also described that there were several cousins within the family, again, looking to the Wilson side of the family tree, that suffered from anxiety and severe depression and alcoholism. Then we heard from Christy. And I'm just running through quickly on the family tree in terms of issues within the family tree. Christy talked about her brother, who is now schizophrenic. She didn't give us a date on the diagnosis, but he's a schizophrenic. That several members of her family struggle with alcoholism. And within Pam's side, meaning the Wilson family tree, there was issues with manic depression and anxiety. So trauma, neglect, and dysfunction. So this is Chrissy with Mark Sr. I don't have pictures of Chrissy with a broken nose. I don't have pictures of Chrissy with a black eye. I don't have any of those, but we know they happen. She was 15 years old when he came to her family and he had their approval for her to live with him. At 15. He didn't take her in the home to make her his wife. He took her away from her family, away from her school, away from her friends at 15. So the dysfunction that we're talking about doesn't start with Chrissy and Mark Sr. This is going up Chrissy's family tree. You don't have a functioning family that lets the daughter go off like that. And what does she describe? There's physical abuse, that she becomes pregnant with Junior, and then she describes an incident where he's threatening her, puts his hand to her neck, and is choking her out. Which leads us in part to Dr. Quinones, and he's now talking about Mark Wilson Jr., right here in court. And he gives us the list of adverse childhood experiences that Mark had gone through. Emotional abuse, physical abuse, sexual abuse that you heard from Dr. Meadows testify to, that Mark had explained that to him also. Physical neglect, emotional neglect, mental illness, an incarcerated relative, parental separation. You remember Chrissy was tearful when she explained that Senior had taken her son out of state without her permission, and all those years that she's trying to figure out where her child is. And substance abuse. So Mark's born 1990, and here's a picture. It's Chrissy, Mark at the age of 1. There's Senior, and then there's Joan Monnier, that's Senior's mother, so Mark Jr.'s grandmother. So at this point, she's 16. She's already gone through multiple episodes of domestic violence. And she tries to get away, and she talks about that. So by the time Mark's 4, Chrissy left Senior. Physical violence, the emotional abuse. She's 19 at this point. And Junior's left in Mark's care. And Mark Sr. does not care for this child. Mark Sr. has this child to get back at Chrissy. She made that clear. So 3rd grade, 1998, 1999, this is the last year that Chrissy has her child in Florida. Mark takes him out of state, they go to Arizona, go to Oklahoma, and they move on. But Senior's violent habits don't stop. He leaves Chrissy, and he starts a relationship with Kim McMahon, where he continues on with the violence. Then he leaves Kim McMahon, and he takes Junior and goes to Arizona, again, where he continues on with the violence. Now she described, and I'm going back a bit and I apologize, but when Junior was 6, so 96, she files another injunction for domestic violence against Senior. And around this time, that's when Kim McMahon has her first son in 96. So let me interject at this point, Dr. Warner, because she's relying on the information for Mark Wilson Jr. on himself. And the timeline kind of moves a bit, because remember she said yesterday that he started the crack cocaine when he's with, at the age of 10. Actually, she said 12. But depending on which doctor you talk to, a different drug or different timeline starts. And why is that? Because his memory has impairments. He knows he starts crack cocaine with Kevin Woodard, but he starts crack cocaine with Kevin Woodard when he comes back from Arizona. That would put him at 2014, 14 years of age at the earliest. But all those drug use that he has, the dates are kind of here and there. Because we don't have records. Because of the way that he was living at that time. But he gives his answers as best he can. So the following year, he's living in Arizona, so that would be 2001. And that's where Nadine is introduced. Nadine and her 3 children, Travis, Cody, and you heard from Kelsey Bilberry. And those children, with Mark, witnessed what seems to be the most violent years, at least that we know of, with Mark Wilson Sr. It'd be one thing if it was violence, but it trades back and forth between violence and neglect. So if they're not witnessing Nadine being beaten and beaten and beaten, then they're just left alone. Left alone to find out their own food, to perhaps get the neighbors to help, and at times to steal. And why are they left alone? Because Nadine and Wilson Sr. are off on a drug binge. So 13 years of age, put you at June of 2003. So you have Senior and Nadine with the constant drug abuse. Nadine has multiple broken bones. And then we have that car accident. Again, I have no records for it. Kelsey Bilberry describes that there were multiple car accidents, but there was the big one where the car was totaled, where they almost went over the cliff. And why? Because Senior fell asleep while he was driving the vehicle. Likely because he was intoxicated. But it was meth or crack or alcohol, we don't know. So finally in 2004, and this is where Kelsey's knowledge of Mark ends. But it's really important to understand how that whole relationship, that whole family came to an end. Kelsey made it clear that Senior checked them out of the hotel, the Tucson Inn. He left all of those children with the waitress. The waitress did not take those children to law enforcement. She took them to work. Senior and Nadine are gone. So you might think, oh, she's just being kind and holding on to the kids while Nadine and Senior are off on a drug binge, but they're checked out. They've left the building. Later on, Kelsey learns that the reason why the waitress had those children is her intent to take those children and traffic them. That's one of the stories that Kelsey can give over that 5-year span. So what else happened? Does she give details? Does Mark? No. Most of Mark's family still thinks this happened in Oklahoma. You heard his mother yesterday or 2 days ago, and she corrected her, no, it was Arizona, not Oklahoma. Because even Mark still talks about this as we got left behind in Oklahoma. Is he falsifying the memory? No, he just has got memory impairments. So Kelsey told us that they're constantly moving. There's too many schools, she couldn't count them all. There's multiple car accidents. But Kelsey was different. She said that she saw what it's like to live in a home where your parents prioritize the drugs and not you, the child, and said she wasn't going to do that. And when her brother Cody went to prison, she took in her nephew. And the state then asked with another expert, well, if Kelsey came out okay, why couldn't Mark? Well, we got to look at the context. When Kelsey got away from Senior and her mother, she went to a stable home with her father. Mark did not. Kelsey's looking at that group of 4 or 5 years of just horror, but she didn't start her life. There's a big difference to the life that she lived versus what Mark continued to live. So Mark goes to school in Arizona. He's living with his grandfather, Richard. They're in the 7th grade. We know that he had to repeat the 7th grade. And we know that the drug abuse is pretty heavy at this point. It's already started because we heard from Dr. Scully Danziger. She's the one that ran through the drug interactions. She's a toxicologist. So the substance abuse in childhood and adolescence can have serious ramifications on brain development. He's using methamphetamines, he's using cannabis or marijuana, he's abusing prescription drugs, right? There's stimulants, there's cocaine, there's alcohol, there's inhalants, meaning he's spraying things and sniffing on them. All of these things on a developing brain of a child has an impact. You heard that from Scully Danziger and other experts talking about the impacts of these drugs. But Scully Danziger also discusses that at the time of the offense, that Mark's drug use, that there's meth, that there's prescription drugs, sounds like it was Klonopin, and that there's marijuana. Because we know that night, just before the last time that Mark saw Sarah, that there's cannabis use. So after the horror of those terrible years in Arizona, Mark comes back. Just for a few summers, and then he moves back for good. But he comes back, and here he is with his little sister, Kayla. And what does he do? Does he pick on her? Does he tease her? Does he give her a hard time? I mean, he just went through some horrible years of not knowing where the next meal is coming. Now he shows his little sister compassion. Remember the story? It's kindergarten, and she's scared. And this is the big brother that comes in and tells her it's going to be okay. This is the big brother that walks her into the kindergarten room and tells her she's going to be all right. And he just came out of unspeakable horrors that we don't know, living in all these different places, in hotels and different homes in Arizona and Oklahoma. But he shows love to his sister. So in Arizona, his grandfather refuses him, places him in a group home. And then he comes back to Florida and lives with his mother's father, John Atkins. And he goes to Interlochen High School, and he's finally in one city, in one house, for a solid period of time. One school. Is it perfect? No. But it's a lot better. So Raymond Atkins, his grandfather. Mark's living with his grandfather, Raymond Atkins. And there was a time where he abused alcohol. Mark had explained to the experts that had continued when he was living there. His mother testified that she didn't see that because he was on different medications. But for Junior, this is the most stable home that he's ever had. But Junior's going to high school as an addict. He's not just using, he's an addict at this point. Crack, cannabis, cocaine, or crack cocaine. But this is the grandfather that shows him love and care and takes him fishing. Shows him that the way his father treated women isn't the way to go. And that's what he follows in terms of he's treating women. No history of him being violent. He had several past girlfriends, but you know what he didn't have? No one gave him any treatment or counseling for the trauma. Not once. So the state, and I'll come back to this, the state has provided you with aggravators. And I'm gonna look at just this one, this cold calculated premeditated. Because Mark has admitted multiple times to his actions. He's accepted responsibility for the horrible crime that he's committed. But the state had everyone at every opportunity inquired about the why. Now, you've heard his statement, you remember it. Now, he tells his mom that I thought the first half was done, that I was supposed to, meaning go forth and take those bullets. He also says at one point that I did something, she told me to do it, and then she didn't tell me to do it. He had made statements to Detective Usina that he thought the boys were sexually assaulting or sexually assaulted his daughter. He also said at one point that he was doing it to protect his family. Then he said that he believes that they raped his daughter and they tried to cover it up. The same conversation, he goes on to say that he hadn't been sleeping for 3 days and he had meth use and clearly some paranoid issues there. The question is, if he's admitted to this over and over and over again, it's recorded, it's documented with 2 different individuals, more than once with his mother and also with Detective Usina. I have to bring you down to it won't be the last paragraph, it'll be near the end with the aggravators on co-calculated premeditated. In order for this aggravating factor to apply, there has to be a heightened level of premeditation, a substantial period of reflection. He has testified multiple times to the meth and the cannabis and some prescription meth. That's what he was on at the time of this horrible event when he took the lives of those 2 boys. And he is given multiple reasons that don't make sense. So to send the doctors in to get another, or another, or another, you've already convicted him. I would submit to you that the heightened premeditation is not there. But it's for you to decide. You can still look at all the aggravations and say that the mitigation is light, or even that it doesn't exist, and still vote for one. Same conversation with Usina, he said several times that he had blacked out. He doesn't remember cleaning the knives. Same conversation with Usina, he starts discussing what Cindy was doing, that she saw, that she knew. With the legs shaking, that won't stop shaking. Even Usina had to bring that up during that interview. He's confused on his memory of that event, but he has never denied the responsibility for it. After that multiple times he's seen it. I'm sorry, I'm corrected. Remember he talked to Aunt Pam? So he confessed to his mother, he confessed to Yasina. And then after that, it's consistent, but he talks to his Aunt Pam and tells her, oh, no, it wasn't me. Why was he talking to his Aunt Pam? He was asking her if she could take his dog. He knew she had a stable home. Nothing like anybody he lives with. She had a good life and a stable home, and he's trying to make things look a little bit better, and maybe she'll be more interested in taking his daughter, Kate. Context matters. So young Wilson Jr. meets Victoria Hall, and they start couch surfing. They're dating in high school, they're together, they're a cute little couple. And she gets pregnant, and they have baby Samuel. But he can't be there to raise that child because he's gone to prison. So Dr. Warner, and the state brought this up earlier and they're correct. She had no school records, no records from the Florida Department of Children and Family, no records from the Arizona Department of Children's Services. What was her diagnosis? Substance abuse disorder, adjustment disorder because he's in custody, is how she described it, antisocial personality disorder. And then she said an interesting thing that his meth use, when he gets to about 3 days, he starts to hear voices. So auditory hallucinations. But she, like Dr. Meadows, and we'll talk to him a little more in a minute, kept going on and on about why doesn't he remember the event? Why can't he give details about the event? He's already admitted to it. It would make a little sense if she was going in there trying to do a whodunit. But he's admitted to it. He's accepted responsibility for it. Why does he need to give details? We've all seen the horrible photos. We know what happened. But they're not satisfied because they can't get minute by minute details. So Dr. Warner doesn't have the school records. She doesn't have the Department of Children and Family records. And why is this important? Because she doesn't have a full picture. She has a crystal clear picture on the offense that nobody's debating. Mark said he did it. So she's going in to do an evaluation, absent records about ADHD, absent records about trauma, absent records about what other doctors are saying he needs. And she renders a diagnosis. So Junior shows up again for Caleb. It's her graduation, and he brings flowers. And she was touched that he'd make a point to show up for her. So then Dr. Meadows, he testified yesterday also. He's one of the only doctors that's not agreeing with Dr. Croft. He's disagreeing with Dr. Croft on the tom and said that it's inaccurate because the client was fidgeting or distractible is the word. All right, so Dr. Meadows doesn't agree with the results on Dr. Croft's testing. But he does say that Mark Wilson Jr. has antisocial personality disorder. And there's another distinction with Dr. Meadows. He's the only one that is not of the psychologists. So the radiologists don't deal with patients face-to-face, but all the other doctors deal with patients face-to-face. Dr. Meadows does not. He's forensic. He's not going in to help anybody. He's not going around counseling anybody. He's just forensic. So he comes in with a forensic evaluation. Again, it's not to say that there's school records inches thick. But there's some pertinent information in there. So he doesn't have school records, he has a GED completion. Again, nothing from Florida Department of Children and Family or Arizona Department of Child Services. They're the defense doctors there. And he comes back and says antisocial personality traits, disorder. But you need some more information to get that disorder. He said you need to show conduct disorder before 15. Where's his information about Mark before 15? A defo, he said. Mark. The records matter. Even the few that we have, the records matter. So he says he has conduct disorder, and yet the doctors that saw Junior at 12, 13, 14, and 15 don't see it. It's not just pediatricians he's seeing as a child. He's seeing psychologists as a child. They're not giving that diagnosis. But Meadows and Dr. Warner do. So the only thing that we have from Mark out of Oklahoma is 1 yearbook photo under the name of Junior Wilson. Not Mark Wilson Jr., but Junior Wilson. So the father isn't just taking him out of state. He's taking him out of state and he's putting him under a different name. So Mark and Cindy have Caitlin. And Mark loves his daughter. He really did. He didn't get the chance to do all these things with Sandra, and hold her and change her and feed her. So punishment at this point is 12 individual verdicts. The aggravators must be proven beyond a reasonable doubt, and the mitigators are any reason that you decide as a reason to choose life. And in Florida, the death penalty is not required. It is not required in this case. It is not required in any case. So I do a little gardening. This isn't an example, it's a little worse. But if you throw out seeds, for example, you can throw out seeds and certain kind of plants will just grow. Something like milkweed that makes the butterflies show up. You can throw that out anywhere and it can grow. But if you throw it out in rocky soil, it's not going to grow that tall and strong. And if you throw it out in a place where there's a lot of thorns, it'll get choked out. But you put that seed in good soil where it's going to get some real proper sunlight and water, it's going to thrive and it's going to be a strong plant. See, not everyone can have someone come alongside and move the thorns out of the way. Some do. Mark's life, and the state's right. 4-year-old Mark, 12-year-old Mark is not on trial. He's a grown man. But there are things in his life that he had no control over. He had no control over the family tree with the mental illness. He had no control over the father who was violent. He had no control over the stepfather who put the crack pipe in his mouth. These are things that he had no control over. So even when we look at the drug abuse and the addiction, that wasn't a voluntary action. This is started off in youth and endorsed by the people that are around it. Now, you can take a plant that's in a bad spot and pull it up and put it somewhere else and it will thrive. It's kind of like what you saw with Kelsey. She got out of that bad situation and now she's doing great. Mark didn't get that. He got thorns in terms of his father. He got thorns in terms of drug abuse. He got thorns in terms of all the alcoholics that were around him. That's what he had. That's why he didn't thrive. Even when he went to prison and he got that work release program, he treated the drug abuse and not the underlying problem, the trauma. So after Mark's confession, and you remember this because I was talking to the mom, and on redirect, I wasn't trying to be rude, but I was just flippant asking her a question. I asked her that you immediately go to law enforcement after Mark confesses. She said, yes, ma'am. And the state referred to that as doing the right thing, and she said, correct. And you did that for Robert and Tayton, and she said, Robert, Tayton, and Mark. And I said, for Mark? She said, I wanted him to be safe, to protect him. I didn't want him to die or someone to kill him. That's what she said. So, what is prison? It's not an easy one. It's punishment. When we're talking about the life penalty and the death penalty, it's not a comparison between a hotel and a park bench. It's prison either way. It's punishment. So you heard from Raul Bonasco, and he was a prison expert. And he talked about his work over the years, or his lifetime, I should say, working in different prisons. And he's seen the good, he's seen the bad, he's seen the ugly. And he noted that Mark adapts well to the prison environment. Mark adapts well in the sense that when he's attacked and someone tries to choke him out, he doesn't respond to violence. That's Mark sober. That's Mark in a controlled environment. So when we talk litigation, one of those in there is redemption. You decide what that is. Can a man be redeemed? I would say. Can a man change? And I would say yes. But redemption isn't in the sense of kind of what we would see in a movie where there's a happy ending and he has a great life and a great family. That's not the kind of redemption we're talking here. Mark's never getting out. There's never going to be another work release. There's never going to be a sunny day free of shackles. Mark's in prison for the rest of his life. But it could mean redemption in the sense of he gets a relationship with his daughter, TAITON. Maybe he finds his son, Samuel. Maybe it's the hope of something better. So mitigation is the existence of any other factor not mentioned that would mitigate against the death penalty. Any other. You can look at all the aggravation and say it outweighs the mitigation and still vote for life. That's the launch for it. So in the state of Florida since '94, a life sentence is life. You're never released and never paroled or imprisoned until a natural death. And a life sentence is a life sentence. It's punishment that we're asking you to do. We're not asking you to give him a break. But a life sentence in prison means that he will take his last breath in prison. So 12 individual verdicts is what we're asking you. Each of you would give personal weight or significance to any mitigating circumstance that exists. Even if all the jurors agree on the facts, each individual juror decides a sentence that's more appropriate. You decide. Each juror may lawfully vote for a life penalty, even if there's no mitigating circumstances. The juror is never required to justify or explain or put into words the reason for the vote. The death sentence is only imposed if all 12 vote to impose a death sentence, and one vote for life, one, means the death penalty is not imposed. Now, every juror is entitled to be treated with dignity, with respect, and have the vote respected. So some of you weren't here, and I promise you I'm almost done for a couple of moments. We had different panels, different attorneys talking. But when we say that you're never required to justify or put into words the reason for your life vote, the example given was in the sense of children. You can talk to people about why you should have one child or 5 or none, but you decide how many kids you have. That's your personal moral decision. You don't have to explain to anybody the size of your family, and you have to explain to absolutely no one why you're voting the way you vote. So courteous deliberations, the judge is going to give you this instruction, and it's a legal proceeding that we're in. State of Florida, it should be conducted with dignity, worthy of the matter, and as jurors, it's important. It's an important matter, and it's your obligation to remain courteous throughout the process, listening to fellow jurors and discussing your disagreements. So if you are going to talk to each other, you need to be courteous to one another. But if a juror is demanding why you're voting the way you're voting, you don't have to answer that question. So you've heard Judge McGillen say this more than once, and I'm going to repeat. The law, and this is Florida, the law neither compels nor requires you to determine that the defendant should be sentenced to death. In the days leading up, the state pointed out that this was the man that would take them fishing. But also in the days leading up, this is the man that his mom described that they were calling Martian Mark. He was referring to things that weren't there. This is the man that Dr. Warner explained that he said, and we have this in the evidence also, that he was on meth. And about 3 days, he starts to hear voices. Did Cindy tell him those things? Did he hear those things? But he's accepting responsibility for what was done to them. And in accepting that responsibility and asking the law for your own individual, personal moral judgment to vote for life. Vote for life for Chrissy's son. Punish him, but vote for life. Thank you.
In just a few moments, you'll be taken to the jury room by the bailiff. First thing you should do is elect a new foreperson, since yours was already excused. Foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. When you have reached decisions in conformity with these instructions, the appropriate forms should be signed and dated by your foreperson. During deliberations, jurors must communicate about the case only with one another and only while all jurors are present in the jury room. If the juror goes to the restroom, the deliberations should stop until the juror returns. Legal proceedings brought on behalf of the state of Florida should be conducted with a dignity worthy of that honor. As jurors in this important matter, it's your obligation to remain courteous throughout the process of listening to your fellow jurors and discussing your disagreements. You are not to communicate with any person outside the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during deliberations. These communication rules apply until I discharge you at the end of the case. If you do become aware of a violation of these instructions or any other instruction I've given you in this case, tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phone or any of those types of devices into the jury room. Kindly leave those devices on your seats where they'll be guarded by the bailiff while you deliberate. And during this trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. States exhibits 1 through 8, 10, 12 through 27, 29 through 31, and 34, and defendants exhibits 1 through 5. If you wish to see any of the remaining video or audio exhibits, please send me them. I cannot participate in your deliberations in any way. Please disregard anything I may have said or done that makes you think I prefer one decision over another. If you need to communicate with me, send a note through the bailiff signed by the foreperson. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any question, if I can, in writing or orally here in open court. In closing, let me remind you that it is important that you follow the law spelled out in these instructions. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we've lived by the Constitution and the law. No juror has the right to violate rules we all share. Would you please hand your copies of instructions over to the side? Clerk, my copy, the signed copy of the instructions, as well as the verdict forms on count 1 and 2. Those will be delivered to you in a moment. At this time, if you go ahead and take out your cell phones or other electronic devices and be prepared to give them to the bailiff. Ms. White and Ms. Sutton, if you would remain seated, you are still the alternates. I'll give you further instructions in a moment. At this time, if I could have the remainder of the jurors retire to the deliberation room. We'll bring in the evidence in a moment. Lunch will be here in about 25 minutes.
All right, so you're next. You can take your notes.
I see the attorney's sidebar while we charge you with yours. Everyone take a seat. All right, so Ms. White and Ms. Sutton, this case is unique, as you know. So even though you are the alternates, I can't excuse you. So we're going to take you to a different part of the courthouse here. Please don't communicate with anyone else until the jury is completely discharged. We will bring you a lunch meal as well and allow you to use the restroom and things like that. But please don't discuss the case among yourselves or with anyone else until you are finally discharged. So at this point, all right, if you would like to come up this way, our bailiff will escort you around to the room where you're waiting. Get anything out of that room?
I don't think so, Judge. I just instructed everyone to get out of there.
Okay, thank you. All right, thank you. Please be seated. Take up while we wait for the jury. Please make sure the clerk has your phone information. Counsel, if you both would go through the evidence with Ms. Trinisha, and she'll have it taken back to the jurors. Do you want to come up and do that now?
Yes.
Before we phone?
These are the ones that came in at the.
Ready?
Yeah.
Okay. If you have any questions or anything that needs to be directed to the judge, write it on the note. It wouldn't happen, knock on the door. But please, knock on the door. Just don't talk to them.
All right, as I mentioned earlier, we arranged lunch to be brought in for them about 12:15. So when the jury coordinator arrives with it, I'll just send her in there without speaking to them. We'll be in recess pending the verdict to the jury or questions. Please make sure the clerk has your contact information.
Yes, sir. Did anyone call state or?
Tanisha will, yep, they had to leave their number. So.
Is this on, this one, TJ?
You did all right.
TJ. I think she. What you think? Either way. You got that thing you said, right? Which for this, somebody could raise their hand, and somebody could not raise their hand. That's it? Yeah. That's true.
You must have.
What do you think about that, Graham said?
We're live on,
Yeah.
we're live.
All right, so here's what's gonna do now. You're gonna be right there, Sandy's gonna be right there. If it's not guilty. Pound of flesh. They want that pound of flesh.
So, Drew.
That's Susan, yours are out of the-
Yeah.
Those things, you know, most drilling devices do not operate in those.
It's good. Tom. Good. Checking on you, buddy.
Sorry.
That's not.
Did you give us a copy of the did he give you a copy of that one? What the what part?
Oh, yeah.
He did.
Okay, I need number 5, like I said, no.
Just waiting on all the court personnel to get it.
Step out for you. What, that's not right here? No, okay.
Yes. Yeah, we're live. And watching. And we're live. Hey, but I would say, just the sign. Which I don't. Hey, Rose. Okay. See, Colonel Tim? Hey, sir. Hey, no.
You can turn your alerts on. Oh, it's still. Chill, man. You just want the one that.
No. Okay. We'd love to, no, we'd love to be on. So what's the process? Good deal, man. Yeah. Okay.
No, it's not, yeah, that's one of the three years.
Oh, yeah, I see it back. Yeah. I haven't drawn, no, I didn't draw. Yes. Yeah. Coming out. Yeah.
I do. Miniatures, I have it. Five minutes, okay.
Correct.
I got you. Thanks, bud.
I'll kick up my other end.
Yes.
Contemporaneous. Yeah. Anything else? Some of the words I don't have to make a lot. Two. That's right. Little things that happen. I told Sam, let the judge know. So I'm gonna do the Yeah. 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 I didn't know. So too much tradition is called. I know, that was bad.
I will take the pen when I talk about your selection. You heard me. Yeah. So. We're good on our end. Okay.
Make sure we got everybody.
Yeah. I just
Okay.
want to- They got your.
All right, court's back in session. The Honorable Howard Miguel presiding. Please be seated.
All right, good afternoon. I'm informed that the jury has a verdict. I would simply ask that when the verdict is published by the clerk, that everyone who is here observing the trial maintain their silence according to the dignity of these proceedings. If you don't believe that you'll be able to do that when you hear the verdict, then we should step outside now. Anything to take up before we bring in?
There you are.
Let's go ahead and bring them in.
All rise as the jurors enter the courtroom, please.
Ms. Scanlon, looks like you were holding some papers. You can elect as the foreperson. You can next. Dale, please. Verdict forms here that have been completed, the property form, and the clerk can ask for a publisher. Mr. Wilson and counsel, please stand.
In the Circuit Court, 7th Judicial Circuit, in and for Putnam County, Florida. Case number 2020-1021 CF. State of Florida versus Mark Howard Wilson Jr. defendant. Verdict as to be sentenced on count 1. Robert Baker descendant. We the jury find as follows as to defendant Mark Howard Wilson Jr. in this case. A. Aggravating factors as to count 1. We the jury unanimously find the state has proven beyond the following factors beyond a reasonable doubt as to defendant Mark Howard Wilson Jr. in this case. Mark Howard Wilson Jr. was previously contemporaneously convicted of another capital felony, yes. The first degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of a burglary, yes. The first degree murder was committed in a cold, calculated, and premeditated manner without any pretense or moral or legal justification, yes. B, sufficiency of the aggravating factors as to the first degree murder of Robert Baker. Reviewing the aggravating factor or factors that we unanimously found to be proven beyond a reasonable doubt in section A, we, the jury, also unanimously found the aggravating factor or factors are sufficient to warrant a possible death, sentence of death, yes. Mitigating circumstances. One or more jurors found that one or more mitigating circumstances was established by the greater weight of the evidence, yes. Eligibility for the death penalty for first degree murder of Robert Baker. We, the jury, unanimously find that the aggravating factor or factors that were proven beyond a reasonable doubt in section A above outweigh the mitigating circumstance or circumstances established in section C above as the first degree murder of Robert Baker, yes. Jury verdict as to death. Having unanimously found that at least one aggravating factor or factors has been established beyond a reasonable doubt in section A above, that the aggravating factor or factors are sufficient to warrant a sentence of death in section B above, and that the aggravating factor or factors outweigh the mitigating circumstance or circumstances in section D above, we, the jury, unanimously find the defendant Mark Howard Wilson Jr. should be sentenced to death for the first degree murder of Robert Baker, yes. Dated this 28th day of October 22nd in Palaca, Putnam County, Florida, Melissa Stalin, foreperson. Verdict as to sentence on count 2, TAITON Baker, descendant. We, the jury, find as follows as to defendant Mark Howard Wilson Jr. in this case. Aggravating factors as to count 1. We, the jury, unanimously find that the state has proven the following aggravating factors beyond a reasonable doubt as to the death as to the defendant Mark Howard Wilson Jr. in this case. Mark Howard Wilson Jr. was previously contemporaneously convicted of another capital felony, yes. The first degree murder was committed while Mark Howard Wilson Jr. was engaged in the commission of a burglary, yes. The first degree murder was committed in a cold, calculated, and premeditated manner without any pretense of moral or legal justification, yes. The first degree murder was especially heinous, atrocious, or cruel, yes. B, sufficiency of the aggravating factors as to first degree murder of TAITON Baker. Reviewing the aggravating factor or factors that were unanimously found to be proven beyond a reasonable doubt in section A, we, the jury, also unanimously find that the aggravating factor or factors are sufficient to warrant a sentence of death, yes. Mitigating circumstances. One or more individual jurors found that one or more mitigating circumstances was established by the greater weight of evidence, yes. Eligibility for death penalty for the first degree murder of TAITON Baker. We, the jury, unanimously find that the aggravating factor or factors that were proven beyond a reasonable doubt in section A above outweigh the mitigating circumstance or circumstances established in section C above as the first degree murder of TAITON Baker, yes. Jury verdict as to the death penalty. Having unanimously found that at least one aggravating factor or factors has been established beyond a reasonable doubt in section A above, that the aggravating factor or factors are sufficient to warrant a sentence of death in section B above, and the aggravating factor or factors outweigh the mitigating circumstance or circumstances in section D above, we, the jury, unanimously find the defendant Mark Howard Wilson Jr. should be sentenced to death for the first degree murder of TAITON Baker, yes. Dated this 28th day of October 2022 in Palaca, Putnam County, Florida, Melissa Stalin, foreperson.
Would either side wish the jury to be polled?
Yes, sir.
Members of the jury, we're going to ask each of you individually about the verdicts that you've just heard. The questions pertain to whether the verdicts as read by the clerk were correctly stated. Madam Clerk, if you would please proceed with polling.
Lydia Canals, juror number 140, agree that each of the findings in this verdict form is yours?
Yes.
Do you, Mary Farrell, juror number 85, agree that each of the findings in this verdict form is yours?
Yes.
Do you, Tanya Cody, juror number 51, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Mary Reeves, juror number 490, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Dana Cruz, juror number 136, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Kathy Decker, juror number 153, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Karen Russell, juror number 512, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Bobby Miller, juror number 424, agree that each of the findings in this verdict form is yours?
Yes.
Do you, Gail Wright, juror number 249, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Nancy Hughes, juror number 294, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Donna Lara, juror number 349, agree that each of the findings in the verdict form is yours?
Yes.
Do you, Melissa Stalin, juror number 558, agree that each of the findings in the verdict form is yours?
Yes.
Thank you.
Members of the jury, I wish to thank you for your time and consideration of this case. I wish to also advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room except by court order. For many centuries, our society has relied on juries for consideration of difficult cases. We've recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you're also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether to preserve your privacy as a juror. At this time, I will go ahead and discharge you as jurors. If your notes are not out here, they'll be picked up in the room and you can leave them there. The two alternates can come forward and join the remaining jury as they go out. Thank you very much.
All right, just rear next to the court, please.
Thank you. Please be seated. I have a 3-hour time block set aside on my calendar on December 1st, starting at 10 o'clock for a Spencer hearing. Both parties available at that time.
State would be available.
It's immediately before the HIU pretrial that day, so some of you will be here anyway.
It's fine with the state. I don't know how much. I'm just checking. It's generally their timetable, but what are any additional others?
While we're waiting for this Peoples to do that, I will go ahead and I erroneously ordered it before, but now I'll order a pre-sentence investigation by the Department of Corrections to be completed. This gives us 30 days to get that done.
Defense is available that morning.
All right, so December 1st at 10 a.m. We'll commence with the Spencer hearing. Anything else we need to take up today?
No.
All right, defendants remanded to the sheriff and sentencing. And we will be adjourned.
Next, and so 1 a.m.
the truth's in the house. Y'all, bring it up, breaking it down. Hear that call? Facts and defense, a mighty blend. Oh yeah, justice ain't gonna bend. Gable hits, the facts commence. Defensive moves, we